What happens when someone fails a drug test while facing serious felony charges, and how far can the court go to protect the process? Stay tuned, because this courtroom drama reveals the shocking decisions that could change lives forever.
All right, a couple of things here. In 24 CR 1691, you are Deanna Ortiz Preston, right?
Yeah.
Your address is still Johnson Avenue in
Yes.
Fort Hays? All right. Or are you employed somewhere right now?
I just got hired on that team Lions. Part-time.
Okay. What are we doing on this case? She wants a trial?
Yes, Judge.
That's what you want.
Yes.
Do you ever have any contact with Jesus Figueroa?
No, I do not.
If you did, it would be catastrophic.
No.
I would pull your bond immediately. You'd sit this out on jail until we can get this trial.
Okay, I understood.
Are you able to hire a lawyer? No?
Yes, sir.
Or you are able to hire a lawyer?
Yes.
Who have you talked to?
Willard Hall, and I'm also going to take the advice of I need to talk to Gaylor. He's my cousin.
Baylor who?
Rhodes.
Well, he's not going to represent you.
No, he can refer me to somebody. I need help with this, so.
Okay. How are you able to pay for this? If we got you on he's a public defender, which means you weren't able to pay for your own lawyer.
Well, I didn't think that I would need one because it's false allegations. But now that I realize that I do, I have friends that will work something out with me.
Oh, you're getting some help from friends.
I will figure it out. Yes, sir. Plus, I just got hired on it. Yes, I'm transitioning right now, so I just moved. That's my permanent address, but I just moved over to Groves area.
Okay, how long have you lived in Jefferson County?
10 years. I'm originally from Howard.
Yes, ma'am.
Yes.
Let me see her, please. Thank you.
It's been about 11 to 12 years since I heard that actually.
Where were you living in California?
Huntington Beach.
Huntington Beach.
Yes, sir.
There's a beach there, right?
Yes, it's beautiful. Actually.
Just that's one prior failure to ID here in Jefferson County.
What happened in that case? Okay. That had to be a misdemeanor.
It was done. She doesn't have any felonies, I don't believe. She does have some history out of California. She does have some history out of California. She received 15 days in the county jail.
What's California?
She had some DUIs in California.
Say
DUI?
Oh. Okay. All right. Just have a seat. We're going to test you to make sure that you're clear, which is a condition of bond.
Sure.
Yeah. And what else?
I think that's it.
That's it. Okay. Just let's see how she does. Jail felony of theft of property. And the court, as a condition of bond, ordered a drug test. You failed the drug test. You know that. You have methamphetamine and looks like amphetamines in your system. And what's your bond, please?
$7,500.
Okay, your bond is revoked and it is now $25,000. You must have a drug patch as a condition of bond. And of course, using felony drugs here, these are serious drugs, this isn't the way to responsibly deal with this case or any other issues. So we'll try to help you with that.
Thank you. So I need to get the patch.
You're gonna, they'll tell you, you're gonna be, you're in custody, you're arrested, you're in custody
Oh,
until that $25,000 bond is posted and the drug patch is placed. And that drug patch will continue to test you. The next time you do it, next time you test positive on that drug patch, your bond will be revoked. You won't have a bond. You will have to sit this one out.
okay.
And this is the kind of case that gets disposed of more often than not without a trial. But I don't know what the facts are. It may need a trial. But anyway, those are the findings. The next setting is an announcement in 4 weeks. He is your attorney
Yes.
until you, or unless you hire someone else. And so he's your lifeline on advice.
Yes.
All right. Anything else? And if not, you're in custody in this case, and you'll get a resetting in 4 weeks for an announcement.
Whatever you take with you and put it properly. So honestly,
Here.
Yes.
As you know, you are charged with third-degree felony of unlawfully carrying a weapon in a prohibited place, which carries with it up to 10 years in prison. So it's serious and needs to be handled responsibly. What do you want to do today on?
Judge, if I get another reason, I want to get.
4 weeks good?
That's fine.
All right, reset 4 weeks, get a reset. Thank you.
Stop.
And I've got Deanna Preston and
I think both.
I've got 3 cases, but he's only pleading for 2.
Right. Third was to be dismissed.
And third one.
Yes.
Which is 5455. He's pleading to 1980. Will be dismissed. All right, we have 2 cases here, 24 CR 2454 and 2455 with State of Texas versus Richard Brady. You are Mr. Brady?
Yes.
Present with Mr. Turk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictments and the arraignments here? Can we proceed in summary?
Yes, Judge.
In summary, each of these, we'll put these together. It's like 2 victims. In summary, these indictments similarly allege that on or about December 7th, Jefferson County, Texas, you committed the second-degree felonies of aggravated assault with a deadly weapon. Do you understand what you are charged with here, sir?
Yeah.
Yes, sir.
And these are second-degree felonies, which mean in each case you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000 for each case. Do you understand?
Yeah.
Yes?
Yes.
An agreement has been reached where you would be pleading guilty and whatever sentence shall not exceed a cap of 15 years in prison in each case. So it looks like we've got 2 options here. No less than 2, nor more than 15 years confinement in prison on each case. Or you could be sentenced no less than 2, nor more than 10 years confinement in prison. That would be, I'm sorry, that isn't eligible. You could be placed on deferred or unadjudicated probation for up to 10 years in length. Regular probation is not an option because a deadly weapon was used or any aggravated crime. Regular probation is not something a judge can give. If I follow this agreement, in each case, you have no right of appeal of your cases. Do you understand?
Yes, sir.
What will happen, we'll get the plea entered. The probation officer will prepare a pre-sentence report in each case. We'll come back later. Each side will add any information you want me to consider, and then we will. And then I will make the decision. Again, if I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases, sir? Guilty or not guilty? You're looking at him.
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty of these
Yes, sir.
indictments.
Yeah.
A lot of writing going on here. Right, I show you what's marked as State's Exhibit 1 on each of these two cases. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true? Correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
And without objection, it's exhibits. In each of these cases, you have signed documents stating that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read them. You are guilty of the crimes charged and any lesser included offenses. You have given up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true in each case, so help you God.
Yes, sir.
State's Exhibit 1, part of the record in each case. Now, we're going to get a pre-sentence report, and we will return back on October 24, next month. And each side will get to present any additional information. The court will make its final.
If you want to see more real-life courtroom moments like this, where every decision matters, hit that subscribe button now and turn on notifications. You won't want to miss the next jaw-dropping case.